Hello, everybody. My name is Darrell Cartwright, and I'm an attorney in Birmingham, Alabama. I practice in the area of estate planning. And today I wanted to talk to you a little bit about what to expect at the initial meeting that you have with me regarding your estate planning. First, when we have that initial meeting, a lot of times clients ask me, what should I bring? And the main thing that you need to bring is yourself. You need to bring yourself and your ideas of what your wishes are and what your concerns are, etc. Now, to the extent that you have them easily available and accessible, go ahead and bring in. Maybe you've had a financial statement that you presented to the bank in exchange or as part of a process for a home loan or something of that nature. Certainly bring those in. If you're part of any partnership agreements or have any agreements that relate to a business that you have an ownership interest in, bring those in. Anything of that nature, and we can discuss more specifically what may be needed during that meeting. So that's why I like to tell my clients, please do not delay having this meeting to gather documents. I'm not really that concerned at our initial meeting about documents. I may ask you during that meeting to gather documents and send them to me as part of the process, but at least initially, we're good enough if I just get you into the office so that we can talk. I like to have that first meeting so we can get comfortable with each other. You can get comfortable with me and understand kind of what the process is and what we're going to be talking about. I want to have you identify with my help what your personal wishes are, what your primary personal wishes are, and what your secondary and tertiary wishes may be. We're going to discuss any concerns that you may have, whether you have any particular needs for special needs for one of the beneficiaries of your estate. Maybe there's a specific need for a trust for either a minor or even an adult in your life. And we can discuss those in the privacy of my office or by telephone call or video call or however we are handling that. Those are the kind of things that we want to talk about. I want to talk about what your assets and liabilities are. It's not because I'm nosy, but there's a lot of different reasons that I need to know. The first one is for tax purposes. There are some situations even today where estate taxes or gift taxes may apply, and I need to make sure that you're not going to fall in that category. In addition, we're going to talk about probate assets versus non-probate assets. As I've explained to clients before, we can have the most beautiful estate planning documents in the world, say wonderful and great things and do wonderful and great things for the protection of you and your family, and yet those can be thwarted with non-probate assets, which will not follow it won't fall into your estate, and it will not be controlled by these wonderful and great, beautiful estate planning documents that we create together. Non-probate assets are things like life insurance that has a beneficiary designation. Doesn't matter what we say in your will or trust, that life insurance policy will do exactly what the beneficiary designation requires it to do. If it says pay to your child, it will pay to your child, even if that's not a good idea for a lot of different reasons. Joint tenancy with right of survivorship real estate. If you own property with someone else, usually a spouse, but it doesn't have to be, jointly with right of survivorship, it doesn't matter what your will says. That property will automatically go to the surviving joint tenant because that's how it's titled, and that's operation of law. We don't have any control over that. Payable on death, POD or TOD type beneficiary designations, usually from bank accounts. or mutual funds, 401k plans or retirement plans that have beneficiary designations. All of these kind of things will fall outside the probate estate. That's why I call them non-probate assets, and they can have a significant effect on your estate plan. And that's why we need to be very careful and identify those things before we make these beautiful and wonderful estate planning documents and have this estate plan that doesn't work as well as it should because of that. In addition to wills and trust and things of that nature, we'll talk about some other complementary, I call them complementary estate planning documents. For example, a general durable power of attorney or a financial power of attorney, a healthcare power of attorney or a healthcare proxy, an advanced directive. In Alabama, we have an Alabama advanced directive for healthcare, which is kind of a combination of a healthcare power of attorney and a living will. We'll discuss whether you're better suited to have a healthcare power of attorney and a living will, or if you're better off with an advanced directive. And we can discuss the whys and wherefores. There are some other tangential type documents that we may discuss as well, depending upon the conversation and each individual client. And each individual client is different, so we'll address that at the time. At the conclusion of the meeting, after we're done, generally nothing definitive has taken place. Hopefully you may have had some documents for me. I'll have a chance to go back and review my notes, see what makes sense, and I will send you correspondence. I'll send you a letter, and that letter will summarize our meeting, and it will contain my recommendations for your estate plan, what I'm going to recommend that we put into place. I will wait for you to give me the authorization to proceed. I will begin the drafting process, and then we'll hopefully be moving it forward toward a resolution that puts your estate plan in very good shape. Anyway, I hope this has helped, and it makes the estate planning initial conference a little less intimidating, and I hope to see you soon. Thanks.